Hail to the legal warriors. In this video, I'm going to cover a question from a viewer. We had a question I thought was a good one. How can somebody convince a prosecutor not to file a criminal charge? If you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find these useful, please like and please subscribe. It's really important that more people get to see this and more people get the help they need. Now I'm just going to jump right into it. The question was, how can somebody convince a prosecutor to not file a charge? And why would I know anything about that as a defense attorney? Well, I've been a defense attorney for about 25 years or so, but the first 7 years of my career, I was a prosecuting attorney. So I used to be the person that the police would be asking to make the decision to charge someone with a crime. And so I'm sort of going to adjust the question of, instead of, how to convince a prosecutor not file a charge, let's adjust it a bit to just say, what are some reasons why the prosecutor might not file a charge, so we can think about it. Because it's not about the convincing, really, it's about the not filing the charge. And so, first of all, how does it work? Well, the people that investigate crimes are police. And so in some situations, the police directly file a charge with the court. And in some cases, the police are required to send their police report to the prosecuting attorney to decide whether or not there's going to be a charge. And so you have to ask yourself, first of all, do you have a situation where the prosecutor is going to make a decision? And the situations where the prosecutor makes a decision would be all felonies. The prosecutor has to make a decision. And misdemeanors that involve county police officers. That'd either be a state patrol or a sheriff. We can rest assured in those cases, while a police officer might make an arrest, it's going to be up to a prosecuting attorney to make a decision about whether or not they will proceed with the charge. For city non-felonies, you may have watched other videos on the channel, most cities empower their police officers to directly file a non-felony straight to the court without sending it to the prosecutor first. Not every city, but I would say the high 90 percentile of cities operate in that way, and there's lots of reasons for that, but we don't need to cover it here. So if you have a felony arrest, or a situation where it's a county arrest, DUI in the interstate, something like that, or if it's just an investigation, then we know it's going to get to the prosecutor. So how does that work? Well, the police send the reports to the prosecutor, either physically or electronically, and each prosecutor is going to have their own system. And at some point, it's going to come up for the prosecutor to look at it. So what do? Well, they read the report. They don't go call the police officer typically and say, give me some more information, right? They've got this big stack of reports. Mr. Smith comes up, hypothetical Mr. Smith, and they look at the report, and now they decide whether or not they're going to charge Mr. Smith with a crime. And so what are some reasons that they might not file? Well, first could be simply lack of evidence. When they look at the report, there's insufficient evidence in the report where they don't think they can prove the case. And so if your attorney has obtained the police report and there's key pieces of evidence that really supports your case in a way where it could make the difference in the eyes of the prosecutor, it could be an idea for the attorney to send that information to the prosecutor and ask them to consider it when it comes to making that charging decision, so the evidence is more balanced, right? It's not just one side. And so sometimes a prosecutor might look at that and say, hey, maybe I don't have enough evidence, maybe I don't want to fight this case. And the real problem with that is, though, the prosecutor has no obligation to listen to the defense attorney in a charging decision status of the case. And sometimes if your attorney were to reach out to the prosecutor, it might hurt your case because it might sort of speed up your case. Oh, you're calling him Mr. Smith? Well, I was going to get to that in 6 months, but since you're calling, I'm going to look at it now. And why would speeding up the case possibly hurt you? Well, speeding up the case might hurt you because oftentimes there are alleged victims involved. And as time passes, alleged victims become less interested sometimes in the case. Life events happen. Maybe they move away. Maybe they get charged with their own crime. Maybe they don't care as much. And so accelerating the government looking at your case to review does carry risks. So it's not something that we would often recommend if you are trying to convince a prosecutor not to file by giving them new evidence, then it better be some darn good evidence, right? Hey, we obtained the video from Walmart, and it wasn't me that did the theft. It was someone impersonating me, and how do I know? Here's the video. That's not me, right? So we've had that case, and in that case, we may be able to convince a prosecutor not to charge. There would be worth the risk because it might be a smoking gun that they can't prove it because they've got the wrong person. So what's another reason why a prosecutor might not file? Well, it has to do a little bit with what I just said. It would be, hey, they don't have their witnesses anymore. So oftentimes it may take 6 months, a year, it may take multiple years, believe it or not, for a prosecutor to get around to Mr. Smith's case in their pile of cases. And let's say in that particular case they're looking at, let's say it's a case with a bar fight, right? And at the time of the bar fight, the police showed up and they took the alleged victim's name. Mr. Jones is the victim, and everyone says that Mr. Smith hit Mr. Jones first, and there's two witnesses in the case, Mr. Jones and we'll say Mr. Apple. And it's now a year later, and maybe Mr. Jones and Mr. Apple aren't the types who want to respond to inquiries from prosecutors. And so the prosecutor goes, oh, it's a year old. Maybe I should reach out and see if I still have these witnesses and victims available. And they don't respond to the case. Well, the prosecutor may not be too interested in that case. Oh, this is just a bar fight. Looks like it went both ways. I don't have my witnesses anyway. I'm going to decline. I'm going to decline to file this because I can't count on being able to prove this case because I have non-law enforcement witnesses that I need to participate in the case. And it's so old, I can't find them anymore. You can think of a lot of hypotheticals where that could happen. So that's another reason why maybe we shouldn't rush things, because typically the state's case against a suspect does not get better with the passage of time. It gets worse. Also, what can happen? Police officers disappear. They quit. Something could happen to them. They move. They get charged with their own crimes. That does happen. And that can torpedo entire caseloads. And so witness unavailability or disinterest is another reason why a prosecutor might not file a case. What's another reason why a prosecutor might not file a case? Well, they might not file it because it just isn't serious enough looking given their caseload. Let's say they come across a fishing case or a crabbing case. Almost every type of fishing and hunting violation in Washington State, believe it or not, is a crime. And if you fish or hunt, you probably know that. But let's say you come across that type of case and they're already buried. Their jury trial calendar last week had 50 cases on it and they can only take one. And they take a look at the case and they go, well, it's not so serious. They look at his record and they say, he has no other record. He's 55 years old. He has no record. He was cooperative. I'm going to make a discretionary decision to not file a crime in this case. Maybe they don't file anything. Maybe they file a related infraction. But it could be just, they may not file a case because it's not so serious and the supposed suspect doesn't have some type of record. And then I think the final reason why a prosecutor might not file a case I want to cover in this video is they have some alternatives available to them besides filing, right? In a juvenile case, particularly, a prosecutor can refer it to juvenile diversion, and that never gets filed in criminal court then. If you get a diversion offer, you'd get something in the mail saying you have an opportunity to come participate in this program outside of court, and if you complete it, the prosecutor won't file a case. There's things called friendship diversion for some cities, and there's also alternative courts, like there is something called community court that may be in certain jurisdictions, which the case isn't technically filed, and you go to community court to avoid it being filed in court. There's veterans court. There's different things that exist, and so a prosecutor, for a bunch of those reasons we talked about, right? Someone's lack of history, it's not serious, bad proof, missing witnesses. Sometimes they might then try to shove that case somewhere else so there's some type of response, or sometimes they might just do it because it lightens their caseload and they think it's the right thing to do. There's alternative other programs called drug court, stuff like that, but in those type of things, the prosecutor's still filing a charge. It might be a way to get the case dismissed, but in this case, we're talking about reasons why a prosecutor might not file a charge. So remember, the title was convincing a prosecutor not to file a charge. So what to take from this? It's usually not a good idea to convince a prosecutor to do anything because of oppositional pre-charging, because of oppositional reflex. And also, it speeds things up, potentially, which could hurt your case. The exception being you have some absolute, killer defense that we think they need to see that never made the first police report. Now, there's still a risk to that, because if they reject your defense and they file the case anyway, now the in-court prosecutor, which is often different than the charging prosecutor, can say, we already considered that, we don't care. And then you're more forced into a trial stance. Really, the goal in cases, in my opinion, is to, if we can't avoid them being filed, let's get them dismissed by limiting your risk without having to go to a trial. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal problem in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.